Hi, I am Jeffrey Warnick, and welcome to another pod shoot. Today, my guest is Carrie Goldberg. I'm very happy to have this conversation with Carrie. Prior to the conversation with Carrie and the introduction to the topic itself, which is about Section 230, I'd like to tell the story of how Carrie and I got to know each other. I am vehemently opposed to Section 230. I have argued for its repeal. I think I strongly believe with what Ed Snowden had said about, quote, social media. He's described them as surveillance platforms masquerading as social media companies. I think it's the most apt description of these platforms because basically their business model is to do surveillance, and what subsidizes that surveillance is Section 230. So, because normally if they did the surveillance and chose the type of content and employed the algorithms without 230, they would have liability associated with the content. And there should be no misunderstanding that the intention of the passage of Section 230 was to restrict free speech and to basically have guardians who would be given this special exemption, this privilege from liability if they acted as a publisher, as an editor, to basically determine to do content moderation. And so they could edit content. It's not all user generated content, it's user generated and then manipulated content. But not user generated content because the algorithms is a manipulation of all the content. And so um, it was to give immunity to people who wanted to host content, yet be able to moderate it and rid itself of content that it found unacceptable and in contradiction to what the internet was founded for. The internet was founded for so we could intermediate communication, conversation, dialogue with each other without there being any sort of authority figure interfering with our relationships with each other. So, given the fact that I am vehemently opposed to 230, and I have been involved in other platforms in the past, people that comprise this censorship ecosystem that has been referred to, and the release of Twitter files and stuff like that, many of the people who have been members of this censorship ecosystem, I personally reached out to. I sent emails, I made some phone calls to them, and I offered to have conversations with them, to explain why I was against 230, what I thought the internet would look like in the absence of 230, and to discuss whether, from a utilitarian point of view, it was actually a good thing to demonetize and deplatform people. Depending upon really what the objective is. Is it a punitive objective, or is it one supposedly to make us have healthier conversations with each other? I think if the intent is us to have healthier conversations with each other, I think 230 has been a miserable failure. So there's no statistics that have indicated that we're having healthier conversations now, than we did prior to 230, or prior to when platforms decided to actively engage in aggressive content moderation. So one of the people who I did reach out to as I was doing a search, and I had read that there was this bill about somebody proposing that 230 lapse. I think it would. I think the expiration of it is sometime at the end of 2025. Carrie can correct me if I'm wrong. And I saw that there were actually people who provided expert testimony on this hearing about this legislation that supported the sunsetting of Section 230. And I saw Carrie's name. I did a search for her. I wrote her a long message that I tend to do with a lot of people. and she, I think, is the only person that didn't ignore me. So she can judge later whether it's a good thing or a bad thing. But here we are, and so that's the background story to this conversation: is that we have two people, and maybe for different reasons, each believe that 230 needs to disappear. So, but I'm going to leave it to Carrie to define exactly, for those who are not familiar with 230, for her to define what 230 is, what it was intended to do, how it's functioning, and why she believes it needs to disappear. So Carrie, why don't you give
Sure.
yourself why don't you introduce yourself and an introduction to the topic, given that I provided this little bit of background of how we got to know each other.
Well, I have to say that I will pretty much respond to any email about Section 230 and have any conversation possible. But your outreach after the May 22nd hearing, Jeffrey, was particularly surprising to me, given your involvement with some with BitChute and other platforms, that I would have thought that most executives involved in them would have wanted my head on a stake. So I was so intrigued that
the difference between me and everybody else is I'm a free speech absolutist, and they're all frauds. They're full of shit, and I'm not full of shit.
And
So I
the
think
thing
that's
is
the fundamental difference between me and the other people who
right.
make all the false claims that they make.
And the thing is that we have the First Amendment. Like, in a lot of ways, Section 230 has been used sort of. There's a major redundancy. Platforms see it as this get out of jail free card, but they're also like already protected by the First Amendment. But anyways, let me back up and introduce myself. I'm Carrie Goldberg. I own a law firm that's based out of Brooklyn, and we represent people who have experienced catastrophic injuries, usually based on something terrible happening on the internet. So whether it's sextortion, CSAM, online platforms selling suicide kits, or matching children with drug dealers who then sell them fentanyl-laced pills, we represent the pretty extreme end of the harm spectrum. We're not dealing with clients who were called a bitch on Twitter, but we're, like, none of our cases involve platform speech. They're all about situations where the platform was, in one way or another, jointly responsible for the catastrophe that happened to the victim. So I've been in practice about 10 years. Our cases are all over the country. And some of them you may have heard about or read articles about, or we can talk about some of the more media exciting cases, like we had one of the first product liability cases, actually the first product liability case against an online platform back in 2017, Herrick v. Grindr. We also had a well-known case, AM versus Omegle, which the settlement with our client resulted in Omegle shuttering forever last November. So,
do you think anybody has been, and I don't want to interrupt you, but do you think anybody's been more effective at piercing the veil of 230 than you through litigation?
I don't want to be cocky, but it is my 24/7 mission. I'm on a crusade, and I think I've probably had more wins on Section 230 than anybody, and probably more losses than anybody. So so I can't brag about my wins without also acknowledging the losses, but most of the losses in court ended up raising a lot more attention in to legislators and stuff.
Right. A short-term loss could be a long-term victory if an outcome is something that ends up outraging society, and society changes the law because they didn't like the outcome of a piece of litigation.
And that's exactly right. So in our case, Herrick v. Grindr, Grindr was maliciously used by our client's stalker, who sent over 1,200 people to our client's home in person, who believed that they were going to fulfill a rape fantasy with our client. And Grindr knew and refused to permanently remove this user. And our client was getting 23 visitors a day in person. And Grindr told us that they didn't have the technology to remove an abusive user. So we said, well, then your product is defective. You literally have a hookup app for in-person communications and in-person hookups, and you've not like foreseen that sometimes it's going to be maliciously used by rapists and predators and stalkers. Then and you have no method for like removing those people, well, then it's defective. So we sued for defective product liability, and the case got dismissed. We appealed and tried to get it in front of the Supreme Court, but then that theory succeeded other places. It succeeded in the famous Lemon versus Snap case over the Ninth Circuit, and it succeeded in our Omegle case, and it's now one of the bases for the multi-district litigation against Snap, TikTok, Google, and Meta. So it's like you sometimes, you have to be the first one sometimes to bring forward the theory, and it's not always going to work.
And you have the courage and passion to do so.
Yeah.
Hence, which is why I'm so happy that you have this opportunity of at least being exposed to the BitChute community, and the BitChute community being exposed to you, so that they know that there are warriors out there, and you definitely are one of them.
Yeah, I just am not afraid to lose, and a lot of lawyers won't bring a case unless there's been a very clear runway of, because these cases are so expensive and time consuming, and if you don't have the passion with your client, then it's just going to feel like a big financial bleed.
I think you made a statement earlier on, and going back to to 230 itself, the history of 230, and maybe you can fill in the blanks that I'll just give a brief description of right now, is that when the internet began, predating social media platforms, and I really do not like that term social media, because I think they're very antisocial. So social welcomes people in and lets people express themselves the way they want to, and people speaking to each other with mutual respect, that's social. But when people are disrespecting each other, when people are throwing people out because they don't like what they said, and you see some of the content that gets amplified, I don't know how anyone could call that social. So, but again, it's a propaganda term. And it's a very, very successful propaganda term. So, but when the internet was first created, and the issue of, we have this internet, we have these people host, and we have people hosting content, and content is going up, and to the content that goes up, where should the liability associated with that content reside? Should it reside with the host, or should it reside with the person who is uploading the content? And the first case was the CompuServe case, and the CompuServe case basically made a judgment saying, if a digital platform functioned essentially like a digital bulletin board, where it had no real terms of service, it didn't really, and because it had no terms of service, it had no reason to do any surveillance regarding the content that was posted on a bulletin board. Therefore, the platform had no liability. So then about 2 years later, I think there was another case. It was a bulletin board. I think it was like a stock trading bulletin board, where people would exchange stock tips. And to simplify it, basically that case ruled against the platform, because the host did have a terms of service. The host did list permissible and acceptable behavior and unacceptable behavior. The host did do some surveillance or monitoring the platform to make sure people were in compliance with the terms of service. And given the fact that the host of the service was monitoring the content, had rules of engagement, and was proactively enforcing, whether diligently or indiligently, or not diligently, they were enforcing, well or poorly, those terms of service, that made them ultimately responsible for the content that was on the platform. So they were not granted liability. So now, as the internet begins to grow and there's a lot more content going up, people said, who basically, some of the authors of 230 said that the internet would be like the wild, wild west. And they and right now, if you have a system where once you start create a terms of service, and and the only reason to have a terms of service is your intention is to actually enforce it. So if by doing that you made the platform liable, and if you had no terms of service and functioned just as a bulletin board and didn't do any surveillance at all, and just let free speech reign, then you had nothing to worry about. Well, Congress didn't want that. Congress didn't want free speech in the digital domain. They wanted to incentivize people to do surveillance, to create a terms of service, to do surveillance, and to remove content that whoever was hosting thought was objectionable according to the host's standards, and to know that as they were making these decisions, which are editorial decisions, that they would be granted a special immunity that no other, quote, publisher, whether it's digital or physical, is entitled to. They didn't make the distinction between publisher or whatever. They just said user-generated content, okay? And whether you're a publisher or not, or editing or not, it's go ahead, moderate to your heart's content. And as long as you do it in, quote, good faith, whatever good faith means, that don't worry about being liable for your actions, even though now it seems like, given the fact that algorithms are much more prevalent in both restricting and amplifying content, the question is now who's responsible for the algorithmic manipulation of content? And it seems like the door has opened up for there to be platform liability for their interference with user-generated content. So that's if you think I've said anything dumb or wrong and like to correct me so I don't misinform the people watching, can you please go ahead and correct me, and then talk about what 230 actually says?
Yeah, no, this was beautiful. Yeah, so it really went into effect in '96 and was the result of Representatives Christopher Cox and Ron Wyden, who basically said, yeah, that computer services should be treated as distributors and not liable for conduct content that they distribute. And it was like just this like little tiny segment of a broader bill, the Telecommunications Act of 1996, which was all about regulating child porn. There'd been a bunch of lawmakers at the time who had discovered that pornography was a thing on the internet. Or I'm sorry, the Telecommunications Act was about restricting children's access to pornography, not about child porn. So these lawmakers were like, oh my God, this weird internet thing, it might cause pornography to proliferate. We have to restrict that. And then Cox and Wyden threw in this little thing about distributor liability. And then the following year, in a case, Reno versus the ACLU, everything from the Telecommunications Act was struck down as unconstitutional, but the Communications Decency Act survived. And so it basically, there's kind of two main parts of it. Section 230C1, it provides immunity from liability for interactive computer services with regard to information published by a third-party information content provider. So in other words, it's used by platforms who are sued for things that their users do, or things that their users publish. It's why, if naked pictures are proliferating on Twitter, we can't go and sue Twitter. Instead, the relief is against the individual that is sharing those images.
And even if they have an algorithm where they have knowledge those images exist, and they're amplifying it and showing it to other people who might not organically see it, so far they've been given immunity for those type of algorithms.
Well, there was a case last week that came down Anderson versus TikTok, which actually makes that a little less clear in the Third Circuit
For the first time.
For the first time. In that case, I mean, and also the issue
because basically these platforms like Twitter and Instagram and Facebook in the past have admitted that they've had knowledge of content. Sometimes they've actually amplified this content and shown it to people that was not allowed to show it to, and they did it with the knowledge they were doing it. And so far, there's been no liability associated with any of those actions.
Yeah, and then I just want to talk real briefly about the other big prong of Section 230, which is kind of what's called like a Good Samaritan protection, which makes it so that computer services are not liable for the content that they remove or moderate when they deem it obscene or lewd or harassing. So it makes it so that, like basically there's no liability for removing stuff.
Right. That might be perfectly permissible stuff, content, according to our First Amendment. We might not like it, but it's certainly, and my understanding of the First Amendment was you don't need a First Amendment if you're protecting speech you like and that everybody agrees with. The purpose of these protections is to protect the stuff we don't like and we don't want to listen to, and not interfere with people's right to say things just because we don't want to listen to it. Our choice is to just not listen to it, not to prevent the other people from speaking it, and not to prevent other people who want to listen to it their right to listen to it.
Exactly.
Is that kind of a reasonable understanding of the intention of the First Amendment?
And right, and also like when Section 230 went into effect, there was sort of this utopian idea that if platforms are not, or basically immune from liability and can't be sued for editorial decisions that they make on their platforms, then it will magically make them good actors, and they'll voluntarily keep good content up and remove harassing or bad content. But the perverse result has been that platforms say, hey, we're never liable for anything that we keep up, so we don't really actually have to even be like babysitting this. We don't have to have a fully staffed department that deals with user complaints. If we're a dating app, we don't really have to remove like predators if we don't want to. If we're if we know that, like Facebook, where there's just so much child pornography, if we know that that's happening, we don't have to remove that because nobody can hold us liable. So it's created this like real arrogance in big tech because they think they can just get away with anything. And I think oftentimes their lawyers reinforce that idea.
I think so far up until TikTok, it's worked, and who knows whether TikTok's getting differential treatment because of who the ultimate beneficiary of TikTok is, and if the same fact pattern existed for Meta or X, whether they would get the same treatment as TikTok would get, I don't know. They might not. So they might have been given the benefit of the doubt when there's less inclination to give TikTok the benefit of the doubt. So that remains to be seen. But I don't think it's just hubris, and of course these platforms have tremendous hubris because so many people rely upon them for getting their message out to a massive audience, and to the extent that that they can amplify that or repress it is a lot of power. And but what's given them the power is the scale that they could actually employ these type of algorithms. I've called the algorithms of since the fact is, what do they monetize? They monetize engagement, and what increases engagement is enragement. So I call it engagement via enragement, or through enragement, or by enragement. But to the extent that they have these algorithms. The goal of the algorithm is to increase and improve their engagement, and they're kind of agnostic on what increases that engagement. And if they find that people are angry and frustrated, and that's what gets them in the platform to go fight with each other. And I always used to read about how, well, when during the Jack Dorsey era, that the conservatives would say we can't abandon Twitter because we got to fight with the libs. Is what they would say. Is so obviously that's engagement. Through enragement that keeps people engaged, and that's what gets monetized. So their incentive, given the fact that they're capitalists, and I love capitalism, but their incentive is to create algorithms that keep people enraged, that keep people engaged. So that's not really organic content, but that's artificial content that they're creating as a function of their algorithms that they still get a subsidy for and having immunity for it, as opposed to really being user-generated content that would grow in an organic environment, because this is a very inorganic environment. It's a manipulated environment. I think Mark Cuban, in his efforts, I think recently he said he'd like to own Fox and Twitter and X. And what was his reason for why he wanted to own X? He said, if you control the algorithm, you control the narrative. So, and he would like to have fun, him controlling the narrative rather than Elon Musk controlling the narrative.
I hate it. They just are all puppeteers. Well, Jeff, do you believe that algorithms are speech?
Do I believe algorithms are speech? Well, if the algorithm is speech and the platform is creating the algorithm, then it's the algorithm's expression of speech, and therefore the platform would be responsible for its own speech generated by its own algorithm. So if people thought the algorithm so therefore, should there be liability? Should the platform have immunity from its own algorithms? No, it shouldn't, because their algorithms is a form of their expression. It's not user-generated expression. The same thing with platforms that pay people to provide some set of exclusivity. Is that user-generated content? Is all that sponsored content? I mean, I think that if anyone is being paid, in any form related to their engagement on a platform, it seems to me that then everything they put up is sponsored content that ultimately the platform should be liable for. That's my opinion. I don't know what your opinion is, given how you read 230.
Well, I passionately oppose this notion that the algorithms are speech. There's something else. They're the operations. These are products, and the algorithms are basically the operations for how the product works, how it presents the content and the speech, how it organizes it, who it serves what to. And I totally agree that there should be no immunity when we're talking about algorithms. And algorithms is one of those things.
But whether it's speech or a product defect, you seem to agree with the concept, that I don't want to put words in your mouth, that it is something that the platforms should be liable and responsible for.
Yeah, I totally feel that way. But also, I think algorithms is such an abstract word. I think everyone has their own definition of what one is.
What's yours?
Just that it's like the guts, at least how it's being used. It's the guts of the operation. These platforms are just products, and this is like the inner workings. It's the like the car engine. And so if it's creating an engine that then just kind of explodes and stuff, then the manufacturer has to be liable for it. But it's interesting because this Anderson versus TikTok case, where the court said, which was a case about the blackout challenge, where TikTok knew that the blackout challenge was this thing that a lot of teenagers were doing to basically asphyxiate themselves. And then predictably, some kids died. And TikTok refused to moderate that content. And instead, its algorithm continued to serve it up to kids who then participated in the blackout challenge and died. So the family of one of those children sued TikTok for wrongful death in the Third Circuit, and basically TikTok did what a lot of the defendants in my case did. They said, one of their defenses is the First Amendment, and so the court said, okay, well then, in order to get Section 230 immunity, you have to plead that that the platform is an interactive computer service and that it's being sued for somebody else's speech. So if you as TikTok is saying, hey, we get First Amendment protection, then you're basically conceding that you are the speaker, in which case Section 230 should not apply. And it was that logic that resulted in the case being remanded and TikTok not getting immunity. But what's more interesting is that it relied on some of the definitions in the Supreme Court case Moody versus NetChoice, and we all know that NetChoice is the biggest lobbyist and stuff for big tech, and its success in NetChoice was used to beat down Section 230, which I just have.
Why don't you explain to people what Moody versus NetChoice was about?
Oh God, don't ask me to do that, please. That was it was a Supreme Court case that basically was looking at some regulations imposed onto social media platforms.
And the issue of government's role. I mean, there's been all the release of the Twitter files, and Zuckerberg did his mea culpa, whether it was sincere or not, who knows. Maybe he said it just to avoid potentially Trump winning and putting him in jail for life. So we don't really know what his intentions of suddenly coming out with his mea culpa. But with respect to this revelations of government contacting platforms and pointing out content that they think was either misinformation, disinformation, or something that they felt the platform should look into as part of their safety standards and their own way they did content moderation. So the question is at what point is it coercive behavior, and what point is it not coercive behavior? If we get into this issue of what's coercive behavior or not coercive behavior, everything the government does is coercive behavior. Because the government, if they make a suggestion and you decide not to follow that suggestion, you don't know what subsequent action will occur to you as a result of you ignoring, quote, suggestions that government makes. So government, by its very nature, is coercive. So, so whenever the government speaks and says certain things that have certain consequences, that's coercive. It's not voluntary. The government has a unique capacity of coerciveness that no other entity has in our daily lives. And so, you could say everything the government says is coercive in nature, but then the government claims, well, we're just speaking and we have free speech rights, and we have knowledge of certain things, and we're making that knowledge available, and we're not telling anybody, there's an or else. But the question is there an implied or else or not? Mm-hmm. And I don't know. To me, the evidence is not convincing, that there is, because the evidence is that platforms ignored the government about as often as they didn't ignore the government. So it was about 50-50. If they would have been coerced, and then they would have found a sense of being coerced, then it might not have been 50-50. It would have been almost everything that the government requested, would have been taken down. And then you also have the situation then of you had like Florida and Missouri and Texas, I think, wanted to create rules that basically did not allow the platforms to basically determine their own rules for content moderation. They wanted explanations, so that you had to give, a reason that some court would determine is a good faith or bad faith reason, to do content moderation, and would basically subject every content moderation decision, at least for the affected parties like public officials, who obviously always want their preferences. They want to be protected in a way other classes of people, they don't think have the right to be protected, to basically intimidate them that they could have a lot of lawsuits every time they make a decision, if they make the decision on the wrong person. We have a thing when it comes to corporate governance of a business judgment rule. We generally, so that the standard for choosing bad faith is a very difficult standard. People who run companies have the right to be wrong. What they don't have a right to be is willfully negligent. So if they use their best judgment, which might not be great judgment, but it's the best judgment that they have, and unless you can prove that there was really malicious intent behind it, which is a difficult standard to reach, then the point is not to have companies sued for nuisance lawsuits for every bad decision management makes. So they don't want if management decides to allocate capital in a bad way, we decide in the corporate governance companies would not want to go public if management was subjected to every time they made a mistake that they'd be litigated. So so you don't litigate bad judgment. So the question is with these platforms, do they preserve the right to having bad judgment with their moderation decisions? And I think our whole history of, and since we've had public companies, is yes, you give management the benefit of the doubt, and you don't want to subject management to trivial litigation where they have to prove every decision because somebody doesn't like it.
Yeah, exactly. And
so I think, go ahead. Sorry, Gary.
Yeah, that's like exactly what Moody was about, because DeSantis had proposed a state bill that would actually prevent the social media platforms from deplatforming candidates.
Correct.
And so it's exactly that situation that you talked about a moment ago, where
privilege for them. They want privileges.
Mm-hmm.
They always want privileges. They want preferences for themselves, for their friends, the people who write them checks, who contribute sufficiently to their campaigns. So, one of the things that was never released in the Twitter files, because it was a selective release, and I think if somebody's going to release things, release everything or nothing. So don't cherry pick. So, so I think whoever cherry picks, I generally on anything, I always assume they're acting in bad faith, because they know they're cherry picking. They don't want the truth to be revealed. They want their narrative to be revealed, which is different than wanting the truth to be revealed. The best, if you want the truth to be revealed, you do one of two things. You either release everything, okay, or you randomly select sufficient content that represents a representative sample of all the requests that come in, and then release those to the public, because then either you're releasing everything or a randomly generated sample that's sufficiently large so that it could be used as a statistically valid sample of what everything else would look like. But you don't pick and choose stuff. That's a dishonest way of doing things. Cherry picking is dishonest. So the release, whatever, I mean, a lot of people say Musk is a great hero because it released. Yeah, I think a lot of people who like the people who were embarrassed by the revelations, I'm sure were very happy. But then there's all the other issues about how many people who liked the people who were embarrassed might find that there's other requests made by people, if they went public, that they would be very upset that those requests were made public. So Elon Musk wanted to tell a story. He showed it to certain preferred journalists. He didn't make it just accessible to the public, and nobody knows how that sample was selected. If an honest person is selecting a sample, in my opinion, they would use the methods that I had suggested, either release everything, or come up with a random generator where you randomly select a sizable sample and have the public take a look at it and to see who was making requests. And, we don't know, we have no idea if celebrities are making requests when they saw content and said, I'm getting off Twitter if you don't remove these people's content. And maybe somebody said, well, this is a huge account, we don't want them upset. I'm just speculating, but we don't know whether that existed or didn't exist. All we know is the little bit of narrative that they want us to know, and the rest of the story, they don't want us to know and will never show us. So we're only seeing their narrative. That's going back to Cuban's point that's their narrative control. It's not the truth. But for people who like that narrative, and want to treat that narrative as it's the truth, of course they're happy, circulating that. Look what they said. But for me, that's not treating people fair. I would treat people fair if I knew I saw a random sample or saw everything, and then I could make a judgment on how biased it was or unbiased it was. Mm-hmm. But we didn't see a randomly generated sample, so we didn't see anything that might have been admissible in a court of law as saying, this is real evidence, because it was cherry picked. So I'm speaking a lot, so
no, it's interesting.
So I'm very passionate about a lot of things, but this is one of the topics that I'm very, very passionate about, and that's why I'm involved in BitChute, because we don't do, if you look at the front page of BitChute, there's a popular and there's a trending, and those are just simple algorithms that we don't intervene with. It's what's popular is just a simple algorithm of that's just basically showing the behavior of the community itself, right? We're not manipulating the community. It's a summary of the community's own organic decisions. So we're just letting people know the product of the decisions that they're making. Yeah. But then we're not throttling or shadow banning or doing any of that. And we don't have any manipulative algorithms. I'm not, besides being a bit shooter, I'm a Bitcoiner. So, to me, what's the thing about, being a bit shooter and a Bitcoiner? Okay. One is, to the great most extent possible, censorship resistant ecosystems. The other is to have an honest ledger. For me, when the ledger should tell a history of the content that's being put on, and it should not be subject to manipulation. So that might be boring to people, but it's honest. Once you have an algorithm, you're manipulating the ledger. You're telling a different story than the organic behavior of the people who are interacting. You're changing the story for it to be the story you want to tell, not what the users are telling, because you're determining what content gets priority and what content other people don't see, what gets throttled, what people are entitled to reach, what people are not entitled to reach, that they don't have that freedom. So they can speak, but they're not necessarily going to be heard. So these are decisions that, to me, they're dishonest ledgers. So they're all just a consequence of cherry picking. It just depends upon the method and tool used, for cherry picking content. And obviously the winners love this. If you're an influencer, that's your model, and you're a winner at this game. The fact that somebody's going in, intervening, and amplifying your content and giving you recognition, obviously this is a game you like very much because it's working to your benefit. So, and you don't care about to the people who have a detriment of their being throttled and stuff like that. You don't care about them because this is just a model for you to have influence and making money off the influence you have. So they're natural allies of this type of immunity, because they might find that the platforms didn't have this type of immunity and made these decisions. They might not amplify the content. And if they didn't amplify the content, then the question is how much more would they be noticed? Like, say, for example, Elon Musk. Elon Musk, has absolute control over Twitter. So to the extent that he is amplifying content, is he doing it on his own behalf? Is there a difference between his behavior on Twitter and Twitter's, or X, and Twitter's own behavior, given the fact he has absolute control over it? So is his decisions basically Elon Musk decisions, or are they decisions that should be made that the platform should have liable to because he has absolute control over the platform? I would argue that any decision he makes, maybe the lawyer, I don't know which side of the case you'd want to be on, Musk's side or my side, but I think he should have liability for the decisions he makes and what content he amplifies and what content because he has absolute control over the platform. So, and we don't know what algorithms that give priority to his since they're not public, and he doesn't seem to be very interested in making them public. Maybe he'll change his mind about that and accept the challenge of Mark Cuban, but he hasn't so far. So, what do you think about where liability resides for somebody like Elon Musk, and possibility that there might be algorithms that make sure that everything he says, everybody on the platform sees? What if that's happening? I'm not saying it is, because I don't know.
Yeah.
What if it is?
Well, I think, like, in my cases, I'm a litigator, so I would need to know how people are being damaged from that. And so if, let's say that Elon Musk was posting deepfakes of Taylor Swift, and then his profile got all this like privileged treatment, and the algorithm like really promoted his profile with these images that then caused her harm, and there's like some deep fake legislation that's on the horizon, then I think that absolutely there would be liability for Elon Musk in that situation, because he's the speaker, but also if he had control over the algorithm and in amplifying his voice over everybody else's, then he also would be implicating Twitter as well. And especially like just applying the Anderson versus TikTok case, if that ends up being applied to other jurisdictions like the Ninth Circuit, that could really clobber social media platforms.
Oh, given, I agree with that assessment. So given that you are one of the few outspoken people who want 230 to be sunset, I have a couple of questions for you. One,
but also I want to just kind of contrast that scenario that we just talked about to, like, if Elon Musk were just posting recipes or just neutral content, and the algorithm was amplifying his voice, there's no harm. So just the him getting that special treatment, there's nothing unlawful about that. These are private companies, and I think a lot of people forget that, but these companies do like get to regulate speech on their platform. Yes, if somebody's harmed in a serious way, I will sue them, but there's nothing illegal about them doing something, even if though it would kind of upset us. Like if they just chose like Elon Musk or you or any random person that they get to amplify, that's not like, I mean, they're not the government. They don't have to treat all speech equally, and I guess the government doesn't have to either. But
they don't have to treat all speech equally, but to the extent that they treat certain speech that might be illegal speech, and they decide to give preference to illegal speech, then the question is should they preserve immunity
right.
for promoting content that is not legal? I mean, clearly, any content that is not violation of any law, should be permitted. And if people want to amplify content that they like because they want other people to see, I have no objection to that. The issue is when somebody's charged with speech that's illegal speech, and they've amplified that illegal speech. The question is why is not the platform jointly liable with the individual that produced that speech since they amplified that speech? Or is it okay for them? Are they a co-conspirator? Are they aid and abetting? By, one thing is allowing is if the user puts that content up and the only one who sees it are people who that follow that user.
Mhm.
But then if a platform says, I want a lot more people to see this illegal speech, and I'm sending it to other people who would have never seen it if it wasn't for my intervention, am I aiding and abetting
Well,
that's that
there's
that,
yeah,
that, that illegal speech?
and there's a case in the Second Circuit called FTC versus LeadClick, which basically says that if the platform is aware of malicious speech on their platform, then just the unlawfulness of that speech transforms it from third-party content to the platform's own content. And then there's a case in the Fourth Circuit, Henderson, which says that liability is required to attach when there's improper content within the platform. So, like, there are some courts are embracing this idea that like unlawful speech changes the speech, like changes the speaker, and when it's illegal and the platform knows about it, then they're responsible for it as the speaker, and therefore can't have have 230 immunity.
Yeah. So what my basic objection to the 230 is that it subsidizes surveillance. So there would be, because you could do surveillance, you can create a terms of service, you can engage in behavior that might be deemed illegal, and then you're immunized for it. And if you didn't have 230, the behavior would be very different. Platforms would, and this is why I think a lot of influencers like 230 is if the platforms were liable for, had a greater degree of liability for the content they decided to put up, and it was not all considered user-generated content because of all the manipulations that these platforms do to the content. Then the question is what would it make very different decisions about what content was there and what content was not there if there was liability that was attributable to the platform itself. For me, I want a world where there are bulletin boards, and where there's a complete absence of surveillance. That's not a very good business model, but it's a good free speech model. So, so right now you don't really, unfortunately, in the digital world, being a free speech platform is punished, not rewarded. So, people want to see, advertisers want to see content moderated. And of course, platforms that rely upon, Elon Musk first started off saying, I think his exact words were pretty much, fuck you to the advertisers. And now after the advertisers said, okay, fuck you, we won't advertise with you. Then he's decided to sue them for not advertising with them, given the fact that he told them to fuck off, and now he's unhappy that they actually took him
They
at his
fucked
word.
off.
They
They,
fucked off.
they fucked.
So I don't know what he wants. Do you want him to fuck off or not to fuck off? So I guess he's confused and schizophrenic himself on this topic. But he seems to be very upset that he told them to fuck off and they took him at his word for it and they fucked off. So he only has himself, to thank for that. So that's their speech rights of determining of what platforms they want to be affiliated with and what content they want to be
Yeah.
affiliated with. But unfortunately, we live in a country where people say, I love free speech, but I don't want to be affiliated with platforms that promote free speech. And again, a platform like BitChute doesn't prefer any specific content. It's all organic. So this is the type of platforms that advertisers should support. They should support every individual having a right of freedom of speech and a right to try and get reach, and trust the marketplace on who gets reach and who doesn't get reach. So
Yeah.
people should trust the decisions that people make in the marketplace makes. Because I tell you one thing, I'm sure that a lot of the people that the advertisers don't want to advertise to are very happy when those same people go into their stores and eat at their restaurants and and buy their merchandise and consume their services. So so on the one hand, they're hypocritical in saying they don't want any relationship with these people, because they do. They want to sell them shit. So, but but they don't have the courage to say, we're agnostic about who we sell shit to, but we're not agnostic about where we advertise with. But yes, we ultimately want all these people to buy our shit, to eat at our restaurants and to and interact with us, in our business. But to me,
Mhm.
the sad thing is that as a society, people are making decisions that repress free speech, that encourage preference falsification. So I don't even know that, we don't know how many people are saying things they don't believe, just in order to get attention to themselves, or in order to be able to monetize themselves. And so therefore, our speech might be significantly less authentic. And the other way is we also might, because of algorithms, we might be saying incredible stuff that we never would say, except we know the algorithm will give us more attention if we say this incredibly stupid shit that will attract the algorithm to circulate our content much broader than it would be in the absence of algorithms. So think about how this is probably changing, our behavior, which is why I think, these platforms are antisocial. And I think the most social platforms are platforms like BitChute, where people get to where it's all organic.
Yeah.
But going back to the questions I wanted to ask you, one is for people who want to help you um, convince Congress to have the sunsetting of 230. How can they contact you? What should be doing? So, what's the advice for people who agree with your position on 230? What can they do to help you, or help themselves, or both? To get involved in the effort to see 230 disappear, sunset, next year.
Mhm. Well, I mean, the first thing they should do is contact me. I'm super active on Twitter at CA Goldberg Law. Um, and email me info at cagoldberglaw.com. But also, like, I think it's really, we have some really big cases like against Grindr and Amazon, and it helps to get more attention and focus on those cases. We're, we have just clients who are like, some of our clients are just like, 19-year-old students, and the more support that we can get for those cases, where we're, at our firm, we're trying to get case law improved on Section 230, and we're carrying the weight of the world on our shoulders. And so if we just know about more people that agree with us, that helps, because every case that we have amicus briefs that are being filed by the lobbyist organizations for big tech. And so we need more love and support on our cases. I mean, this case that I have a Ninth Circuit argument for against Grindr, they're saying that the the platform deciding who gets to use it and doesn't get to use it, or like basically, like whether or not they age gate, they're saying that is speech. And so in our case, they let a 15-year-old kid with autism and ADHD use their platform, and then matched him with 4 different adults that raped him. And Grindr is saying, well, it's that kid's own freaking fault because he lied about his age, except that when you create a Grindr profile, it tells you to be 18 and then asks you if you're 18. And they also advertise on TikTok and Instagram, with children actors who are like at school in gymnasiums, and talking about being gay. And so then they're surprised that other kids who are gay are using their platform. It's repulsive, but it's also important to note that, like, companies have a responsibility to not hurt people. And that's what a lot of these social media companies and like dating companies kind of forget about, is they think, well, as long as we're not liable, then we can hurt as many people as we want to. We can, amplify algorithms that encourage kids to choke themselves to death. We can sell kids suicide kits. As long as we're not liable, like, let's throw morality off, out the window. But we're here to say that you are legally and morally liable.
Yeah, my bias is always to go towards the outcome that would be produced by the common law system. And the
Mhm.
common law system is what produced the first two rulings. And common law systems are much better, in my opinion, than legislation. And that courts generally figure things out reasonably well on these type of cases. And to the extent that they make mistakes, there are other judges out there that will correct mistakes made by others, because we still have, for many courts, except the issues get to the Supreme Court, we have basically still a reasonably decentralized system. So it's hard to reverse decisions made by the Supreme Court. So, but other courts, reversing bad decisions is much easier. So, and reversing legislation is also almost impossible.
Right.
So,
And
the bias should always be towards common law solutions to things, not legislative solutions.
I 100% agree with that. And a lot of people don't remember the fact that Section 230 is a regulation.
Right.
It's, like, removing it is not, like, people, some of the most libertarian people I know are like, no, we have to keep Section 230. Free speech.
Because
But
again,
no,
there's
Section
like
230
the free speech.
regulates the internet. It doesn't deregulate it. And free speech doesn't go away without Section 230. All Section 230 does is create this perverse system where the most ruthless, omnipotent, wealthy companies in the history of the universe don't ever have to be held liable for the outrageous harms that they do.
I agree. To me, someone is a free speech fraud and a libertarian fraud if they support 230.
Thank you. Amen.
The common law system gets it right. Anyone who really supports free speech understands that that we inherited a great common law system, and we've messed it up through regulation and legislation, and when we legislated less and regulated less and relied upon the common law system to work, we got much better outcomes with the common law system. So we should trust the common law system rather than the centralized systems of regulation. And you're right. It's curious that libertarians who supposedly are anti-regulation seem to like this regulation. And you're right in saying this is that this is regulation, and libertarians are not supposed to like regulation. So they're free speech frauds and libertarian liars, in my point of view.
I love that.
So that's just my opinion. So how can people stay in contact with you, Carrie? It's
Twitter.
be a great
Twitter's,
conversation, but
yeah.
tell everyone here how people can continue to stay in contact with
Contact
you.
me
Not appearing here.
on Twitter. My CA Goldberg Law is the best place to find me.
Well, thank you so much. I'd like to say I hope people who either watching this live or watch it later, I hope they will give great consideration to providing financial support to Carrie in her litigation, and to Carrie in her efforts. And if for anyone who really believes that we should repeal 230 and let it sunset, there were only at the hearing there was only Carrie and one other witness there. So that tells you who really cares about this issue, and who doesn't, and Carrie had the courtesy and decency and maybe the stupidity to answer my message.
No.
So but I think that speaks very, very highly of her, because ultimately most people are not really willing to engage in a dialogue or conversation about it. They just want to have a monologue, and they just want an audience. and Carrie's one of the few people who actually was willing to have a conversation, and I have a lot of respect for that. So I hope all of you continue to follow Carrie wherever she is and give her the financial support so she can continue this very, very important fight, because I think this fight is not really just about 230. This fight is how we preserve free speech, and there are few legitimate free speech warriors, and Carrie's one of them.
Thank you. Thank you so much, Jeffrey. Well, I also want to thank everyone who's watching and listening too.
Thank you so much.
Okay.
Bye.